We're going to start with number 199, People versus Pavone. Counselor? You want any rebuttal time, Counselor?
Yes, thank you, Your Honor. I'd like 1 minute for rebuttal.
1 minute, you have it. Go ahead. You're on.
Good afternoon, Your Honors. Our position is that, in this case, the prosecution in the court committed reversible error by the prosecution questioning.
What did they ask? What did they ask him, and at what point?
In cross-examination of the defendant, he was asked whether, when he was taken into custody, he had anything to say at that time.
What's the significance of that? Is silence?
What's significant is that, in essence, the prosecution was asking the jury to infer from his silence on that subject that his EED defense, which was the only issue at trial, was a concoction.
Did you object to that question?
Yes, that question was
That's the
objected
one that
to.
was objected to?
That's the one that was objected to. And
how did that prejudice the defendant?
Well, it prejudiced the defendant in the most basic way because it asked, in essence, the jury to infer from that silence at that time, after Miranda warnings, that the reason he was silent is that, in fact, extreme emotional disturbance defense was a concoction that he came up with later. So what kind of error is it? Is it a constitutional error? It's a constitutional error we submit, although we also submit that even if it's not a constitutional error, it still would be reversible error because, in this case, the evidence was not overwhelming. And specifically, we're talking, of course, about the evidence against the extreme emotional disturbance defense, which, from the very start of the trial, was the only issue that the jury had to decide.
You don't think that defense was disproven?
We submit that it was not disproven. We argued at the appellate division that the jury's verdict rejecting that defense was against the weight of the evidence. But
well, the burden is yours, right?
The burden is ours, yes, but it's only a preponderance of the evidence. We certainly don't have to prove beyond a reasonable doubt that we were operating under an extreme emotional disturbance. The appellate division judges all concluded that there was, in fact, an error, but the majority concluded that the evidence against the extreme emotional disturbance defense was strong enough to be characterized as overwhelming.
What was that evidence in the appellate division's view?
What was the evidence against the defense? Is that what you're asking?
Yeah. What makes this harmless in the view of the appellate division, and I'm sure of your opponent?
Well, according to the appellate division, I would rather leave this to my opponent, but my understanding is the way the majority felt about it is that because the defendant before the crime, and we admit it was a crime, the defendant before the crime was seen by a couple of witnesses residing in the same building where one of the victims resided. He seemed to be calm at that time. The appellate division thought that was very significant.
Was there expert testimony on the side of the people that said that he was not suffering from EED at the time of the crime?
Yes, there was, but of course there was also expert testimony on behalf of the defendant, a very qualified expert. I believe he was a Harvard undergraduate, Yale residency.
You had not heard the auditory evidence, correct? And he admitted that that evidence was important and significant and would have been helpful, did he not?
I'm sorry, you're asking whether the
defendant's expert, correct?
Defense counsel did admit that he didn't listen to that and that it would have been helpful.
The expert.
Yes.
So that's part of your ineffective assistance claim, isn't that
That's
correct?
part of the ineffective assistance claim, that there was
What I'm wondering there is there really a 440 motion? Is it really outside the record entirely?
Well, we don't think that it is outside the record. I mean, there's no reason no legitimate strategic reason can be proffered to explain why defense counsel wouldn't have provided the expert with those recordings.
The way I understand your theory is that the audio recordings themselves would have shown the emotional state of the defendant, and that so they were essential to listen to, not just look at a transcript.
Yes, I didn't hear the last part of your question.
That they were essential to listen to because you can tell somebody's emotional state by listening to them.
Yes, they were essential to listen to.
Right.
Now, I don't think that in and of itself makes the defense expert unworthy of belief, but it was something that the jury could consider, and the jury might have considered that to be very significant.
But what about the defendant's own conduct in terms of what seemed like sort of a controlled act on his part, coming back, doing what he did in a very deliberative, or looked like a deliberative fashion, knowing exactly what he was doing? Does that have any effect in terms of disproving the EED defense?
Are you referring to his having left the apartment and then returning?
Yeah.
The jury could certainly take that into consideration, but evidence like that really cuts both ways. For example, the appellate division seemed to suggest that this might have been planned by the defendant, but if it had been planned, then why didn't he do it when he got there? What was the evidence was
Well,
that he was
again,
talking.
up to the jury in the end.
That's something that the jury could decide. It doesn't make the evidence overwhelming. In fact, it seems that he was in his own mind, he was undecided about what to do, and he was so.
You know, Judge,
But it does-
I'm sorry, Judge, you go ahead.
But it does suggest that there is, it's not that the record is bereft with evidence that the jury could have relied on. There really was a reservoir the jury could rely on to decide that you didn't carry your burden. You may want to argue it the other way, but it's not that there's not enough or that it's lacking. You've got that he left. You've got that he shoots when people are already down. You've got that he steps over her as he's going back and forth. Right? So you've got lots of things that suggest that there's evidence there that a jury could look to and say, I'm not persuaded that he snapped at this time, that this is really an EED.
Well, that may be, Your Honor, but in this context, the issue is whether the evidence was overwhelming.
Does the Williams case have any impact on your argument about whether it was overwhelming and whether it was inconsistent with sending the defense to the jury?
Well, I submit, based on the Williams case, if you're referring to the case that the prosecutor brought to you, I submit that suggests that there's a very high burden that has to be met to establish that an evidentiary error like this is harmless. That was, in my view, in the Williams case, there was very strong evidence of the defendant's guilt, and the issue there was also, it was not a constitutional issue, it was a non-constitutional issue, so you had the significant probability standard, and yet this court found that, nevertheless, the error was not harmless. And I'd submit, applying that standard here, we'd have to reach the same conclusion. It's not
Okay,
harmless.
counsel, you'll have your rebuttal. Let's hear from your adversary. Let me make clear to everybody that Judge Abdus Salam will be participating in this case. She is watching it by video but unable to be here with us. Counsel?
Thank you, Your Honor. Good afternoon, and may it please the Court. Nick Ivanovich for the people. Your Honors are being asked to reverse this conviction. And
It was error, wasn't it, the question that was asked that really related to the silence of the defendant?
Well, let's talk about directly where in the record you're referring to, Judge. Are you talking about the cross-examination question? Yeah. I don't think we need to submit that was absolutely an error. I think that what appellant is not raising is a very important part of the record, A304, where it is on direct examination. He is the defendant himself, who is testifying, is asked, did you take these two shots? And the defendant says something very particular. He says, everything was so slow, I can remember some of it is burnt in my mind. You can't forget something like that. It's over a bit of a couple of sentences, but he says that, and that is very near the end of his direct and the beginning of the People's Cross, which is when that question is asked, Your Honor.
That's different from his point about the silence equals that EED is concocted, right? The series of events can be quite memorable.
Certainly.
Right? But the point about the EED is a different point, is it not?
The point about EED is certainly, I think, applies to the entirety of the case. So I agree with Your Honor. But I think
with respect to this error.
With respect to the question, which we don't concede necessarily was an error, was
well, that's one of the problems that I was afraid you'd raise, because if you don't get the message, it seems to me that someone's right to remain silent is important and constitutional. Maybe we got to do something to make it clearer. What should we do to make it clearer other than harmless error? Because harmless error says you can do it again, in my view.
My apologies, Judge.
Sorry.
I couldn't agree with you more that this court needed to be forthright and forceful and clear, and you were in Williams. Williams made it clear that this is against evidentiary standards. There was an objection in the case in chief, and there was an objection in the opening. We as prosecutors get it. We understand it. You were clear in that standard. I think that in the country right now, as you see different courts dealing and grappling with the constitutional issues of silence versus self-incrimination, this court has made a reasoned and appropriate and clear.
But what makes it okay here?
Well, again, it's separate on the parts that are not objected to. I'm not arguing.
Just talking about the cross-examination.
Just dealing with that, Your Honors, we're clear in Williams that there are circumstances, including what we see, those unusual circumstances like in Rothschild and Savage.
But you think that his general description about what happened and what he remembers, you think that gave you license to then get into his silence?
No, I think it gives license into when the answer is, I can remember some of it, it is burnt in my mind. That gives us two very specific needs at that point.
Judge Geary, in her dissent, said whether a defendant's silence is used as part of the people's direct case for impeachment purposes or as here to challenge a defense, the implicit promise, the breach, and the consequent penalty are identical, and the unfairness is not altered. Do you agree with that statement?
Well, I think that was a decision that was before Williams and before we had guidance. I don't necessarily, because there are different rules.
Well, one of the problems I think that she was raising is, as Mr. Conley pointed out, is if you're trying to imply by someone exercising their constitutional rights that they were using that time to concoct a defense, I think you would agree that that's not a very nice thing to do.
And it's improper, and against evidentiary rules.
And that's the point here, right? I mean, you're making the point that he didn't raise the EED defense, when he was first arrested. Well, maybe he didn't know he had one.
No, Judge, and I think it plays right into where I was saying there's two things we're getting at really with that questioning. That line of questioning, if Your Honors look at the totality of it, that line of questioning, because the defendant was never questioned on cross about, well, you didn't tell investigators Hyman, you didn't tell investigators Waitman. Those are the direct case unobjected to. That question on cross is not about his exercise of his right to remain silent. Those lines of questioning on cross are what was burnt into your mind and what wasn't.
Let's go back to when you said you didn't say anything to the investigators, and you're saying that was not objected to.
Yes.
Does that in your mind mean that it's okay?
No.
Then why did you do it? I guess not you personally, of course, but why would the people do something? I mean, this is so fundamental. It burns in my mind sometimes that they know, the police officers knew. You can't tell somebody that or question somebody without telling them they have a right to remain silent. And yet the district attorney, the prosecutor says you didn't say anything to the investigators. And a proper answer from him would be, nobody told me I had a right to remain silent. But you're in the middle of a trial and that doesn't pop up. And it just seemed to me it's just so clearly improper you'd never dream of asking it.
I think that it came about through the selective silence, but I know this court since, and the only reason I raise that isn't to argue selective silence should be treated differently, because Your Honors have made it clear now, don't treat it differently. It's against the evidentiary standards of the state. We get that loud and clear now, and I think
Because of Williams?
Yes.
Did you think that's a new rule?
It's not necessarily that it's a brand-new rule, but it's when this court finally has issued what I think is clear is we're dealing with this under the evidence of the state. And I think there were some complications with the constitutionality and what is silence versus self-incrimination, and other courts are dealing with this.
This wasn't complicated, right? This question wasn't difficult to figure out what was appropriate and not inappropriate.
I don't disagree to some extent, Judge, but I think selective silence issues prior to the Williams case did raise some.
All right, but your basic argument is it may well be error, but in this case, not dispositive.
Absolutely correct. To look at the
Because why?
Well,
the evidence is overwhelming?
certainly, Judge, but then we
How
have
is the evidence overwhelming?
Well, first, I'd just like to say that the scrutiny the court applies is certainly important. And on a constitutional question, it's very different from an evidentiary question, which is very different from an ineffective assistance question. So assuming one of those errors that the court would find,
Let's assume it. Go ahead.
apply the appropriate standard of scrutiny, and let's look at the evidence. And what do we have?
Go ahead.
We have days of stalking by this defendant.
You keep bundling this thing up, and as I think Judge Stein mentioned, the appellate division was unanimous that this was improper. Right. And yet you're not ready to concede that, are you?
No, I am ready to concede it as improper.
Okay.
We are, Judge. We've heard this court loud and clear. This is not something that needs to be admitted into evidence.
So what's your overwhelming evidence?
The overwhelming evidence, Judge, is over the days prior and leading up to. We see this stalking behavior by the defendant. And you can hear on all of the audio tapes that Your Honors have been provided in the record, the very first part of the record for you, you can hear the defendant's voice. You can hear his manipulative
How
tactics.
do we discern the difference between that being part and parcel of the EED and stalking?
I'm trying to all of that would go to the EED defense. The defendant's emotions leading up to and then very close in time and then very thereafter all play into this. And when Your Honors look at the evidence in the days leading up, certainly the defendant's emotional. That's not a question. There's almost no murders that don't have any emotion in them. That's almost impossible. So I concede he was emotional. But he wasn't extremely emotionally disturbed. Your Honors can hear in his voice, 1:36 in the morning. Let's go right to the time in murders. Within the closest message we have from the defendant at 1:36 in the morning, he says, "Tim, I know you're getting these messages. I'm still looking for my girlfriend." That's his tone of voice. You can listen to it on the recordings. This is not a man who is emotionally disturbed.
I'm not prepared to make that judgment. I know what you mean, and you know, as you listen to them all, that's why when I was questioning Mr. Connolly, you know, I think expert testimony is rather important in this case, don't you?
I do think expert testimony is important, and that's why Dr. Stuart Kirchner, who wrote the book on EED really in New York State, who testified for the prosecution, really focused narrow in time closer to the murders, as opposed to Dr. Wecker, who ultimately really was arguing that throughout these recordings, over days, this defendant, that was his testimony. Your Honors can refer to the record that over the days leading up to there was apparently the subjective EED. And that's just not credible. That just doesn't fit with the evidence of the defendant, who to everyone else in the world is acting in a way that's methodical.
But it's not incorrect. But the general concept that EED is not necessarily in that one moment, right? That it can be prior to the one moment when the murder is committed in this particular case. You don't disagree with that?
No. No, I don't disagree that, A, the subjective EED...
You think he just went too far back in time?
No, I think that his expert opinion that it lasted this entire period of time is incredible. I see my time is up. I would ask that Your Honors affirm the appellate division's decision in all respects.
Okay,
Thank you.
Let's hear rebuttal, counsel.
The factors that the prosecutor cited that, in his view, tend to disprove the EED, I submit would do no more than create a question of fact for a jury to resolve. For example, he brings up Dr. Kirchner, who admittedly wrote an article that's considered to be maybe a seminal article on the EED defense. We concede that. It's in the record. On the other hand, 90% of the EED examinations that he performs are performed for the prosecution. So jury could reasonably find that this is like a hired gun. On the other hand...
well, I think all the judges here would recognize that that's usually the case with expert testimony. The problem is, though, is Well, take a step back. First off, I agree with Judge Piggott on the question of selective silence. I think it's clear, and I think we're really talking about harmless error here. The appellate division was relatively consistent. In my personal view, the case seems to be that's clear. So we really have to get into the question of what the nature of his actions were during the time that he said he was suffering from EED in this particular. And then then it becomes more difficult for you. He kind of calculates and stalks the victims. He inquires and establishes their contact numbers. He's polite and seems to be aware. He's able to handle machinery, create a ruse about the heat problem as he's going from house to house. Of course, capably use a gun and contain an entrance and obtain an entrance through the use of violence. Those kind of actions. Then, of course, afterwards, the appellate division calls it consciousness of guilt. I assume they're talking about the fleeing from the scene and a level of calculation and his demeanor throughout it, I think, are the phrases they use. And those become more difficult for you than I think the pure question of silence. So, on the element of control.
You mean his controlled demeanor?
Yeah.
There is evidence to that effect. I agree. On the other hand, there's a lot of evidence going the other way. His testimony, and granted, a lot of it is his testimony, and the jury had an opportunity to hear that, but that's something for a jury to decide whether he's credible. His testimony.
In the end, what standard should we be using to determine whether it's harmless error or not? In your
Well, it's a constitutional error, so the evidence has.
That's not inconsistent with Williams?
No, how would that be inconsistent? I don't see how it would be.
Well, didn't we say it was state evidentiary question?
No, this was a constitutional issue because the question was when you were taken into custody, and that's a post-Miranda. When he was taken into custody, he was given Miranda warnings immediately, and therefore that's a constitutional violation. But in any event, even under Williams, where there's the standard is a significant probability and overwhelming evidence, this court found that there was a significant probability that the error could have made a difference.
Okay, counsel. Appreciate it. Thank you both.